Thank you, Your Honor. I object to the court giving the Commonwealth an opportunity to make a speech describing what they claim is the evidence elicited by the grand jury to play to the assembled media. The district attorney's press release invited the media to come here today to hear more facts and circumstances about the case, even though there is no reason at all to have a speech by the district attorney's office about what they say the facts are. And the court has just played along with that. This is not supposed to be a spectacle. It's not supposed to be a sporting contest. The defendant has been subjected to an avalanche of publicity, none of which we're responsible for. We've been subjected to wild and extravagant stories which have been reported as if they're true based on unnamed law enforcement sources. It got so bad that the judge assigned to the Bristol County case has entered a gag order in order to try to assure a fair trial for Mr. Hernandez. We're assembled here in the largest courtroom in this building for a proceeding that should take 2 minutes, but which is not in the confines of the courtroom that you usually sit in, so that this poisoning of the jury pool can continue. It's not fair. Whether the defendant is a football player or a poor person arraigned in the 7th floor clerk magistrate session, he's entitled to the court's assistance in securing him a fair trial. So I object to the court giving the district attorney's office an opportunity to present its one-sided view of the case after a one-sided grand jury proceeding, and to call it fair because I can stand up without having had an opportunity to look at the box of 50 DVDs that we're told we're getting, go ahead and comment on the case. That's not fair. The Commonwealth summary serves no other purpose than to prejudice the potential jury pool. It doesn't serve any purpose for the functioning of the judicial system, and the courtroom should not be used as a vehicle for this purpose. 62 years ago, Justice Frankfurter said that for the prosecutor to feed the news media would be to turn the courtroom into a trial by newspaper rather than a trial by jury. For us, Aaron's lawyers, for Aaron Hernandez, for his friends and family, I say come back when we have a jury, after we have a jury, when you can see witnesses, you can see cross-examination, you can see evidence, and then listen to the case. That's all we ask for. We don't ask to be treated differently. Just give us a fair trial, not one tainted by unfair, one-sided, unnecessary, prejudicial publicity. Thank you.
All right, thank you, Mr. Rankin. I've given you an opportunity to speak, and I'm not going to address all the issues that you raised. I will note that this arraignment started approximately at 1 minute past 2, and now, if my eyes are correct, it's about 16 minutes past 2. So this has been a very quick proceeding. I will also state for the record that I've conducted over 1,900 arraignments in capital cases in Suffolk County since 1983. And in each occasion, the prosecutor has been afforded an opportunity to speak, to address the court relative to the facts of the case. To do otherwise would be violative of custom and procedure that dates back quite a few years, long before my tenure in this court. And I was not going to preclude the Commonwealth from telling the court about the case that they present today. And I've afforded counsel an opportunity to speak. I could not envision a proceeding where the press would not be invited to attend. We do not operate behind closed doors in our system of justice in the United States, let alone in the Commonwealth of Massachusetts. So this is an open proceeding. The press, as always, is welcome. I do not control the attendance in this courtroom. You are correct, Mr. Rankin, that I usually conduct these proceedings on the 7th floor in the magistrate session. The proceedings usually take about the same amount of time. We run anywhere from 15 minutes to 45 minutes on an arraignment, depending upon the presentation made by the parties. And there's absolutely, positively no issue of bail. The defendant is a detainee, and the Bristol County has a hold on him without bail. The Suffolk County District Attorney is asking that he be held without bail. I'm going to hold him without bail. The next scheduled court date will be before Justice Locke, the regional justice in this county. It'll be in this particular courtroom, which is his courtroom, and it'll be on the 24th of June, and that date is by the agreement of parties. Relative to the statements of the Commonwealth has presented what they wish to present in court. They're well aware of their professional obligations under the Code of Professional Responsibility. And I find that the Commonwealth's presentation in the normal course of this case is a usual presentation that I've heard at least 1,900 times before. Thank you very much. Go ahead.